First, I'd like to make the standard motion to dismiss based on insufficiency of the evidence as to all 7 counts and contend that the state has failed to meet its burden with regards to sufficient evidence on each element of each crime with all 7 counts. And I'd like to address that, Your Honor, count by count if I could.
Yes, sir.
The first count, 1, in the indictment alleges the jurors for the state upon their oath present that between April 1st, 2016 and October 24th, 2016, the defendant named above unlawfully, willfully, and feloniously did conspire with Craig Blitzer and Cindy Blitzer and unnamed others to commit in Wake County, North Carolina, the felony of obtaining property by false pretenses, and it sets forth statute 14-100, and it alleges the victim as the state of North Carolina. It contends further this act was done in violation also of GS 14-2.4. Within count 1, Your Honor, the allegation is a conspiracy. The elements of a conspiracy, as I've set forth from my research, is that parties enter into an agreement to commit an unlawful act with the intent to be carried out. And the unlawful act alleged is obtaining property by false pretenses, which North Carolina law indicates includes elements that there's made a representation that is false, calculated and intended to deceive. The representation does in fact deceive, and a person obtains money or goods. So taking first the conspiracy, I would contend from the state's evidence there is no indication that an agreement was entered, first of all, between me and Cindy Blitzer. The relevant parties and goods here is a salary with accompanying benefits. The hiring is approved through AOC, and state's evidence has been presented to the jury that Cindy Blitzer did in fact work the hours that she recorded until around mid-March. Summarizing, I would contend the state's evidence then, if believed, is that Ms. Blitzer was told by her husband, Craig Blitzer, that I had been informed that she didn't have any work to do, and the representation by the state is that I said that was okay, she could concentrate on her schoolwork. With that as a basic premise, I know that doesn't summarize all the evidence, but I would contend that does not represent evidence of an agreement between myself and Cindy Blitzer to obtain property by false pretenses. And further would say, certainly not within April 1st, 2016 through October 24th, 2016. I would contend fundamental fairness and due process has to alert the defendant as to when the agreement was entered. In this particular case, there is some evidence that it occurred on some date in April during an Ocracoke trip. I'm not conceding that was an agreement, but I contend the closest thing to an agreement that's been offered by the state is that an event occurred where I told Mr. Blitzer that it was okay for Ms. Blitzer to not work and concentrate on her schoolwork. First, I contend that is not an agreement. Certainly there is not an agreement between me and Cindy Blitzer. To the extent the court considers this an agreement between me and Mr. Blitzer, and that somehow Cindy Blitzer, who actually enters into the time, created some type of agreement as contemplated by North Carolina law under this conspiracy, then there must be a date in which that act occurred. Certainly the defense should not have to defend every day between April 1st and October 24th that was the date where an agreement was entered. And so, in addition to a general argument that not all of the elements are met for the conspiracy to commit an obtaining property by false pretenses, I would move to dismiss it, and then more specifically ask the court to consider the evidence and whether or not what facts indicate that at a certain moment in time an agreement was entered between either me and Cindy Blitzer, or me and Craig Blitzer, or me, Craig, and Cindy Blitzer. I simply contend the evidence is insufficient on that point, but to the extent the court feels like there is sufficient evidence to go forward in a light most favorable to the state, I would ask to at least dismiss the part of this indictment of every other date other than the date the state contends this agreement was entered. With regards to indictment 2, well, before I leave 1, Your Honor, I know that this is notice pleading, but this is going to be a recurring argument in count 2 and 3. The other issue before the court, which you can consider in the conspiracy charge as well, is that the representation makes a representation that is false, calculated to deceive. There are multiple facts the state may argue to the court meets the requirement of making a representation that is false. With regards to the specific charge in count 2, the allegation is the defendant named above feloniously did, with intent to cheat, defraud, obtain money, services, and other things of value, approximately $28,000 in salary, vacation leave, sick leave, and medical insurance from the state of North Carolina by means of a false pretense. And then they set forth this specific allegation. The false pretense, which occurred in Wake County, North Carolina, consisted of the following. The defendant, by and with his fellow conspirators, submitted fraudulent entries of hours, worked for Cindy Blitzer to the state of North Carolina Administrative Office of the Courts, indicating the fact that she was entitled to be compensated for hours that he and his co-conspirators knew Cindy Blitzer had not worked. Again, taking all the evidence in light most favorable to the state, the elements would be making a representation that is false, calculated and intended to deceive. The representation does deceive, and the person obtains money and goods. There is a factual dispute between the state and I would invite the court to please consider this fact, and I've asked Madam Court Reporter to pull a transcript for me. I contend the representative of the Administrative Office of the Courts did, in response to a question of mine, when I asked what would happen if beacon hours were not entered. I contend and recollect that she said the employee would continue to be paid. And I asked what happened after that. After a period of months, she said that the supervisor would get an email. That's one of the reasons why it's critical as the court considers not only the sufficiency of the evidence of the charge in general, but also to give the the defendant notice at this point, what is the false representation? Is it the entry of beacon hours, or is it the approval of beacon hours? And with the last witness the state they did put on evidence for a period of time within this offense period that there was approval, and the state's evidence was it was at my direction. So is that the false representation is the question. And the specific charge is obtaining property by false pretenses. and the allegation is that I did acts with co-conspirators of Cindy Blitzer. I believe that is the specifics that are alleged. So I would contend, first of all, there's insufficient evidence to show that I made a representation that was false, calculated to deceive, that did in fact deceive, and the person obtained money and goods with regards to count 2. With regards to count 3, which is the last of the obtaining property by false pretense allegations, again it alleges this time period, Your Honor, of April 1st, 2016 through October 24th, 2016. The defendant named above did feloniously, with intent to cheat and defraud, again alleges $28,000 in benefits, by means of a false pretense, calculated to deceive and did deceive, and this is the allegation. In count 3, the false pretense consisted of the following. Cindy Blitzer submitted fraudulent entries of hours worked for Cindy Blitzer to the state of North Carolina AOC, indicating the fact that she was entitled to be compensated for hours that she knew she had not worked. This act was done in violation of 14-100. So with regards to count 3, again, the allegation is from April 1st through October 24th. The key, Your Honor, in considering whether or not this is a obtaining property by false pretense is to determine what is the false representation element of this offense. Is it Beacon? Is it approval of Beacon? Or, as I have heard the state argue in previous pretrial motions, is it a representation of employment to AOC? The defendant is simply not on notice with regards to what specific false representation he would be required to defend. First, contend the evidence, even in the light most favorable to the state, would be insufficient to show that I did anything with regards to these elements of the offense, and it should be dismissed. But to the extent that count 3 contemplates some type of acting in concert or aid and abet theory, I would contend that, first of all, in the allegata, the defendant should be put on notice on what specifically he is accused of doing to aid and abet Cindy Blitzer to do this obtaining property by false pretenses. Again, the state's strongest evidence on this point from the defense perspective is that they put forth a meeting in April where I have alleged to represent to Craig Blitzer, who then said to Cindy Blitzer, it's okay for you to submit hours and not work. Now, I know that's a factual dispute, but even if taken as true, does that constitute aiding and abetting Cindy Blitzer to commit the crime of obtaining property by false pretenses? It is not a requirement in North Carolina, but I would remind the court that with regards to counts 1, 2, and 3, Cindy Blitzer, who did obtain salary from the state of North Carolina, is not charged with anything. Your Honor, in terms of shifting now, the 4, 5, and 6 go into a different realm. Before I leave the obtaining property by false pretenses, I would just ask the court to consider, and I would request to supplement with a brief, the unique requirements of obtaining property by false pretenses and the intent requirements at the time that such act was done. First of all, if you took it daily from April 1st through October 24th, the defendant essentially would have to defend, 180 days of each event, or every beacon entry or every time something is approved. I would contend that the state has to put the defendant on notice of the false pretense act that is being alleged during the time period. And I would contend even in the allegata, neither is there a date and time for a conspiracy which requires an agreement, nor specific allegata as to what the representation was. Moving to obstruction, a broader crime, admittedly. I have also moved 4, 5, and 6 to be dismissed based on insufficiency of the evidence, but I would like to address each one individually and point out a couple of things to the court. Unlike the first 3 counts, where it is a time frame, which, in fairness to the defendant, I contend that even if the whole indictment for each count is not dismissed, it should at least be dismissed in part, in fairness to the defendant, to establish a date of the offense. But in count 4, it does allege a specific date, August 12th. The defendant unlawfully, willfully, and feloniously did commit the infamous offense of obstruction of justice. Now, I asked Judge Stoltz about this. The state tendered in discovery an allegation that Judge Stoltz learned from me by phone that there was an SBI investigation with regards to whether Cindy Blitzer was working the hours she was reporting. The statement tendered to the defense, and I probably need to put that in for the court to consider, not just on insufficiency of the evidence, but fairness to the defendant. That telephone call is what the defendant was put on notice, as was obstruction of justice. Subsequent to the telephone call on October 12th, there is a statement in discovery that indicates that Judge Stoltz asked me if it was the same deal and was she working. That statement does not say that I told him to enter hours in Beacon. I say to the court, this is more than just a question of fact. This is a question of fundamental fairness and due process, where the state has drafted an indictment, alleged a specific date of the 12th of August 2016, and alleged the intent to commit the infamous offense of obstruction of justice. And the specific allegation is that there is a criminal fraud case in Wake County, North Carolina, regarding Cindy Blitzer. I want to stop right there. I asked a lot of questions on the state's case. It is very clear that the agent testified that he phone called to me August 10th and said there was a complaint that Cindy Blitzer was not working the hours she was putting in Beacon. Prior to the offense date, alleged of 12 August, there is no evidence from the state that there is a North Carolina State Bureau of Investigation investigating a criminal fraud offense in Wake County, North Carolina, regarding whether Cindy Blitzer was actually working the hours she was claiming as an employee. You even heard a judge on the on the witness stand, state that he was told the same information the agent said he told me. The SBI had a complaint on whether this employee was working the hours. This judge testified, state's evidence, that he believed that it was an administrative inquiry. So even in the allegata, 12th day of August, no notice to the defendant in terms of that the act that occurred on the 12th day of August, when it's provided in discovery that I called then ADA Stoltz to ask what was going on with her hours, it sets forth a crime. Now it does go forward in count 4, saying that I provided false and inaccurate information to Jay Stoltz, an employee of Prosecutor District 9A, and causing him to approve and transmit to the state of North Carolina, Administrative Office of the Courts, Wake County, North Carolina, approximately 6 months of false and unsubstantiated time entries for Cindy Blitzer's claimed worked hours. Where the state gives in discovery, there's a call between me and Mr. Stoltz on the 12th, and then subsequent to that, an allegation that he asked if she'd been working, and then he, on his own accord, does a beacon entry. That is what the defense prepared to defend. That's why I asked Judge Stoltz, did you give another statement since the SBI statement regarding this incident? He said no. State's evidence was that on August 15th, that he came in upon a call from me and first learned of the SBI inquiry, thought it was administrative, and was directed by me to enter approval of these hours. So first of all, and I do want to, when I finish the argument, hand up Judge Stoltz's statement to you so you can assess it from a due process standpoint. I contend there's no notice to the defendant in terms of this act that the state has alleged occurred on August 15th, which they did present evidence. Beacon was approved by Judge Stoltz on August 15th. But the allegata is the 12th day of August, which discovery shows when I first contacted Judge Stoltz to address the issue. In terms of the second part of that indictment, Your Honor, the state goes on to allege, and it is part of the indictment, the defendant did this action to fabricate evidence tending to insulate himself from said fraud and its investigation, and to create the appearance that Stoltz had been approving and supervising Cindy Blitzer's fraudulent entries, thus giving the appearance that time claims were legitimate and thereby impeding, delaying, and obstructing the investigation and legal and public justice. There's no evidence of that, Your Honor. No evidence that any act done by Jay Stoltz, either at my direction or not, impeded, delayed, or obstructed this investigation. The state wants that assumption, but in evidence, Agent Whitley, which I believe is the only investigator other than perhaps Mays to testify, no evidence that this act obstructed the investigation. Now, I concede, as you analyze the first 3 counts, Your Honor, that based on Ms. Tant's testimony, the act of approving does confer some benefit, because she said, by approving the previous time, that at least the gain time, sick time, vacation time, there is some value conferred by the approval of the time. But it is not a prerequisite for salary, nor is, based on the testimony, the entry of beacon hours. So I would contend the strongest argument on count 4, Your Honor, is there is no evidence presented by the state that this act impeded, delayed, or obstructed the investigation. In fact, to the contrary. Agent Whitley testified that Mays went to AOC in April or May, that he went to AOC in early August. They identified that the hours were not approved. Nothing and no evidence to indicate that subsequent to that this magical approval through either July 14th or August 15th impeded them in the investigation. In fact, I spoke with him on the 6th, and Jay Stoltz spoke with him on the 9th. And listening for it, Your Honor, as you heard Judge Stoltz's testimony, there was no question from the state saying, did Mr. Bradsher tell you to misrepresent that to the SBI? That conversation, you heard the misunderstanding, and that in a light most favorable to the state, they can conclude and argue to you that I directed him to approve the time. I contest that, and the statement is in contradiction of that, but nevertheless, they do get that inference at this stage. But to say that act obstructed the investigation, Your Honor, is merely a guess, not based on facts that are in evidence. And I would contend that part of this indictment requires substantial evidence on each element of the offense, and on that, there's none. With regards to 5, in addition to the general motion to dismiss for insufficiency of the evidence, I would contend this also is an obstruction of justice claim, which alleges an offense date of September 6th. No question, there was an interview between myself and David Whitley on September 6, 2016. And I do make the general motion to dismiss that charge based on your consideration of all the evidence as insufficient. However, if the court denies that, I would ask the court to look at the allegata and would contend to the court that the defendant is at least entitled to knowledge at this stage as to what the state is alleging was false and fabricated statements to David Whitley. The allegata does set forth the elements of willfully, feloniously, deceit, intent to defraud, in Person County, North Carolina, commit the offense of obstruction of justice by knowingly and intentionally providing false and fabricated statements to David Whitley, agent of the SBI, who defendant knew to be investigating a criminal fraud offense. Now at that point, although I dispute the facts, I do concede the state gets that inference based on what Agent Whitley testified to. They get the presumption that all their evidence is to be taken as true at this point. But then it goes on to say that it was designed to mislead the agent, thereby impeding, delaying, and obstructing the investigation. The defendant is entitled, if you deny the motion to dismiss, for the state to set forth what false and misleading information impeded, delayed, and obstructed the investigation. So the defense can set forth evidence to defend that specific act. To simply say in blank the entire interview is subject to false and misleading statements is an unfair burden on the defendant. Shouldn't have to defend every word and every inference of the interview, and I would contend that is inconsistent with the purpose of putting a defendant on notice of crimes he is facing. Now to count 6. Again, a general motion to dismiss based on insufficiency of the evidence. I spent a little bit more time on this, Your Honor. It is alleged that on the 11th day of January, the defendant named above unlawfully, willfully, and feloniously in secrecy and with malice did in Person County commit the infamous offense of obstruction of justice by discharging from employment of the office of the District Attorney for Prosecutorial District 9A, Deborah Hallberg, a person cooperating with an investigation of the North Carolina State Bureau of Investigation of a criminal fraud in Wake County. I would stop right there and say, what evidence did the state present of that? Did AOC testify that she was discharged? The SBI agent was asked by me the day after she was discharged, did she call and make a statement? Objection sustained. Hearsay. The only evidence the state offered was a statement from Craig Blitzer, who said that I said she was discharged for talking to the SBI. In balancing North Carolina law and the requirements of the state with regards to substantial elements on each offense, is that sufficient to say that she was a person cooperating with an investigation of the North Carolina State Bureau of Investigation of a criminal fraud committed in Wake County, North Carolina? I would contend not. And furthermore, the allegation with the intent to punish her for said cooperation with the investigation, thereby impeding, delaying, and obstructing the investigation and legal and public justice. Now, Your Honor, when we get there is no evidence of that. In fact, the evidence that I was trying to elicit was just the opposite, but nevertheless it did not come in. But evidence supporting that, we contend, was not put on by the state. Absolutely nothing. In fact, to the contrary, Agent Whitley testified the day after she was discharged. She called him, told him why she was discharged. And maybe the state will tell you what she said in the argument. I guess at this stage, it's irrelevant on the sufficiency of the evidence. But Your Honor, I contend 6 should definitely be dismissed on insufficiency of the evidence on every element. The state simply wants the court to assume that somehow this termination obstructed, delayed, or impeded the investigation. There are, in North Carolina, civil laws that allow for a remedy if, in fact, the state's evidence is to be taken as true, even with constitutional officers. There's case law on it. But with regards to, in this case, impeding, delaying, and obstructing the investigation, there is no indication that that occurred, and that is what is alleged. Not only that, you can construe the language to say it was done with the intent to obstruct the investigation and legal and public justice. And Defendants 30, Your Honor, already came into evidence. Defendants 30 that sets forth that the complainant that began this investigation is Jason Ramey. So November, I think 22nd is the date that the defendant is on notice that Jason Ramey is the person who filed a complaint in this matter. And then there is some evidence that Debbie Halbert was terminated, and a statement from Craig Blitzer that said, I did it because she was talking with the SBI. Again, dispute the facts, but contend it's insufficient evidence on the elements of the offense and that should be dismissed. Finally, with regards to the specific charges, Your Honor, I will make this more summary. And I would also like to supplement in a brief on this argument as well. This misdemeanor statute of 14-230, if you look at the judicial history of this particular statute with regards to failure to perform duties, I contend was never intended for the fact pattern that has been strapped to this statute. The allegation is that I willfully did omit, neglect, and refuse to discharge the duties of his office in violation of 14-230, to wit, continuing the employment of Cindy Blitzer, knowing and having reasonable grounds to know that she was not performing the duties of the position for which she had been employed and for which she was receiving in Wake County, North Carolina, compensation in the form of a salary, vacation leave, sick leave, and medical insurance from the state of North Carolina. Back to the investigator statute. Your Honor, I already alerted the court earlier in the trial. The enabling statute that gives district attorneys an investigatory assistant, as it's called now, or an investigator before, sets forth that there are duties, I'm paraphrasing, to do things in preparation of trial, which you've heard, she did, and any other duty given by the DA. The allegata in 7 simply says, not like 1, 2, 3, says she's not working. It simply alleges was not performing the duties of the position for which she had been employed and for which she was receiving compensation. I would contend, Your Honor, on its face, that does not set forth a criminal offense under the law of the state of North Carolina. And I ask the court, again, if I could supplement with a little bit of brief on that. Your Honor, as to all these counts, there is no question that in the light most favorable to the state, Cindy Blitzer submitted beacon hours. A portion of it was approved, and she did receive a paycheck. However, I contend to the court, in addition to the defendant being entitled to dismissal of all charges, that secondarily, if you rule differently on any of these charges, that at least the defendant's entitled to some relief in terms of the offense dates and the state revealing specific allegata that they are proceeding on in these charges. And with the court's permission, rather than, I have a dozen other short motions just for the record, but I would like to yield to the state before I leave the substantive charges if the court will allow me.
Well, let me ask a question. I mean, with respect to the more specific allegations, you did not seek a bill of particulars in this case, or did you? I don't know.
I did not.
All right. Are you aware of authority that permits this request at this stage of the proceedings? I mean, you're basically asking the state to, if charges are not dismissed, to require the state to be more specific about what those charges are. But do you have any authority that that is appropriate relief that can be requested at this stage of the proceedings?
Well, again, without having the case law to give the court, the court's well aware of a motion of bill of particulars and the defendant's rights to actually get relief for specifics pre-trial. I would contend to the court, based on state and federal law, U.S. Constitution and North Carolina Constitution, once the state has presented evidence and a theory of a case, which this court will determine if those specific facts, taken in a light most favorable to the state, support it going forward, the defendant is entitled to notice of those facts so that they can set forth a defense.
Right, but that's certainly true, but what you're requesting in the latter half of your motion, the alternative relief you're requesting, is to compel the state at this point to narrow its indictment, which is a procedure that is permitted through a bill of particulars, but that's done prior to trial. It's a pretrial motion. I've just never encountered a motion made at the close of the state's evidence essentially asking the state to go back and amend where the indictment was not challenged for jurisdiction or a bill of particulars sought, where at this stage of the proceedings the defense is asking the state to narrow its indictment prior to the defense offering evidence. And so I'm asking out of intellectual curiosity, are you aware of any precedent for that, statutory or case law, that permits such relief?
I do have case law that would support this under a due process argument. And again, Specifically, the motion is not to narrow the indictment. The due process argument is notice to the defendant, not just for the specific facts that the defendant is alleged to have done, but also fundamental fairness on offense dates that are clearly too broad to defend. So it is a constitutional argument.
Okay. All right, very good. Mr. Latour, I'll be happy to hear you on general responses to each of the arguments if you wish, but I'm not sure that's particularly efficient. I am curious about your position on offense number 6, the Debbie Halbrook, and what evidence you would contend exists in light most favorable to the state that the termination of Debbie Halbrook obstructed justice in this case.
Your Honor, I would submit to you that, one, to answer the general question about the Debbie Halbrook, that there was no evidence that she was even fired. The evidence would show, I believe, from including Craig Blitzer, that occurred, and two, I believe Gail Peed testified that she was sitting in the room when it happened. So I would submit there is evidence that it occurred, which I believe was argued that it did not. As to the evidence that it obstructed the justice, I would submit to you that there is evidence that it delayed or obstructed justice or was intended to obstruct justice. If you look at Craig Blitzer's statement, in that the context of the statement that the defendant makes to Craig Blitzer is, you need to fire other people for talking to the SBI because that's what I have done and we demand loyalty. And when you look at it in that respect, then there is evidence that it was intended to delay and obstruct and interfere with the investigation of this, and that it was intended to be done so that people would not speak to the SBI.
Well, is it intent sufficient, or must it actually, in fact, cause delay or an obstruction of an investigation? I mean, the fact that someone intends to delay it, but then it has no such effect on the investigation, and arguably helps the investigation because she then became a whistleblower.
Well, at a minimum, I would submit to you that intent is sufficient, but at a minimum, I would contend to you that it does not vitiate the entirety of the indictment. It would, at a minimum, reduce it to an attempt, and therefore would still be a felony offense in this matter. And so it doesn't make the entirety of the indictment go away. My understanding of obstruction of justice is the only elements are that you unlawfully and willfully obstruct justice. There is no requirement, I would submit, that it do both, and that the intent is sufficient. I'm trying to look at the language. I would contend to you that there is certainly evidence that it would impede the ability to effectuate it because she no longer works in the office. She would no longer have access to things in the office that would have potentially or would have aided them in their investigation. So there's certainly that I would submit to Your Honor. It certainly obstructs their ability to, as you heard the testimony, meet with people at a group setting. She's no longer there. It impedes that ability as well. It would also, I would submit to you, fall under the idea of this intimidating a witness. And in reading it, intimidating witnesses is a form of which obstruction of justice can be effectuated. And so I would submit to you that there is evidence that that's what the intent here was and that that's what actually occurred. based upon the defendant's statements to Craig Blitzer.
All right. All right, well, let me just, are there any other points that you wish to respond to specifically? That was one that came to mind as I was listening to the argument.
The others that I have that kind of stood out to me were the complaints about the date range. It's sufficient, I would submit to you, based on the statutory and case law, that it be alleged the way it is. It is a notice statute. He has been placed on notice as to the events. He did not file a bill of particulars. He now has heard the state's evidence and is free to respond to that at this point based upon what he believes his evidence can show. I think it's pretty clear that the law in North Carolina, as far as the obstruction of, it's not the obstruction of justice, the obtaining property by false pretenses, does not require him to make the representation that it be false, as long as someone that he is acting in concert with or aiding and abetting in their efforts to do so makes a representation. There's clear case law on point about that. As to the conspiracy, I think that the evidence is clear that, in the light most favorable to the state, that an agreement occurred that she would go to nursing school while being paid for things that she was not participating in. As to the question that he raises as to Judge Stoltz's statement to him versus what the evidence is in court, I would submit to you that's irrelevant. The evidence that you have is what is in the courtroom. Whatever documentation he wishes to provide to Your Honor is not for consideration, as it is not in evidence at this point, and he was on sufficient notice. As to that date issue, it very clearly says on or about the 12th. It's within a reasonable time period. The action is sufficiently explained within the indictment to place him on sufficient notice. And other than that, if Your Honor wishes to have me be heard on anything else.
No, that's fine. I think that's sufficient. All right. So, Mr. Bradsher, what I'd like to have is any further authority that you wish to provide to me by, let's say, no later than 8 o'clock tomorrow morning.
Via email?
Yes, sir.
Yes, sir.
With copy to, of course, Mr. Latour.
Of course.
If you will email that to me so that I can review it before we get here at 9:30. If I have any other questions, then I'll raise them. We'll talk about them. But I'll just hold my ruling until that point.
Your Honor. Thank you.
Okay.
May I just address briefly the Debbie Hallbrook count? I would simply contend, Your Honor, as alleged, it does allege that it in fact impeded, delayed, and obstructed the investigation. And just like the following line that said, this termination was accomplished by notice to the Administrative Office of the Courts in Wake County, North Carolina. Well, we all know that, but was there evidence of that? And was there evidence that it actually impeded? The argument is, well, she wasn't in the office anymore. As you consider the sufficiency of that evidence, do we speculate that her not being in the office accomplishes that, or does that require some evidence on that element to show that that occurred? So I will submit that by 8 a.m.
Yes, sir.
May I be heard on the other brief
Yes, sir.
issues?
Please.
Your Honor, I do want to make a constitutional argument. I already made a motion for mistrial on the federal issue, and I'll just renew that motion. I also will add to that a motion for mistrial on a constitutional issue. And I will tell the court that I am arguing for an extension of, good faith extension of existing North Carolina law. North Carolina Supreme Court, State v. Reed, 334 NC 551, which cites a case I know the court's familiar with, Griffin v. California, 380 U.S. 609, with regards to any reference to the defendant's right or failure to testify. In the State v. Reed case, a prosecutor, in closing, simply said, the defendant has not taken the stand. There's an objection. And all the prosecutor does after that is say, he has that right to do so, and you have to decide the case other than that. That's the only reference. But yet our Supreme Court said that was sufficient to order a new trial for the defendant. I would contend the combination of a colloquialism, which I think is used throughout North Carolina by Superior Court judges, every time an objection was made on state's case that the state contended was stepping over the line of the defendant, getting in a statement from the defendant, the court not only sustained, but also made, again, a common colloquialism. You will have the opportunity to testify if you wish and be subject to cross-examination. That occurred many, 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 many times. I would contend that in combination with the ruling that prevents the narrative testimony of the defendant would be an unconstitutional deprivation of the defendant's right to elect, to testify or not testify. The repeated use of that language, and I concede there is no existing North Carolina case law on this point right now, but I contend the continual exposure to the jury of that reference of you'll have the opportunity to testify if you choose and be subject to cross-examination sends a message to the jury that we're trying to prevent, as State v. Reed recognized, to not in any way reference a defendant's election to testify or not testify and to keep that from the jury's consideration. Now, in contemplating what to do, in addition to knowing the jury has heard that repeatedly, the decision to either fix questions up and read questions and answers to the jury or hire an attorney to propound the questions, but not being able to do the narrative. Again, I contend that chills the defendant's right to make that election. And that's just in the form of motion to dismiss, mistrial, and I certainly concede that the court will deny that. I don't wish to argue it further. Your Honor, I do want to make sure that I renew all previous pretrial motions to dismiss based on all previous grounds alleged. Many of them were interlocutory orders. I simply, out of an abundance of caution, will renew those motions now at the close of state's evidence, particularly the decision for Your Honor not to disqualify yourself, which you made and entered an order to that effect, as well as my inability to call you as a witness. I have submitted to the court's ruling thus far in terms of the limiting of examination on state's case with regards to the first 4 years of my position as district attorney. I will contend to the court in this indictment the state has also alleged aggravating factors of conduct done in the scope of my position as district attorney. So I say that to the court now that I guess I'm asking the court if that pattern of rulings will still be in place as the defense puts on evidence, because I understand state's case in chief, you certainly have the right to limit what amount of evidence or cross-examination I do, but I need some direction from the court as to whether or not that is a ruling that you've determined that this first 4 years, other than a summary and general touching upon, which you've limited me to, would be relevant in defendant's case in chief. For example, with Tyler Henderson, the state put him on, talked to him about the years of private practice with me, and then the first 4 years in the DA's office. I would contend to build credibility for him, having worked with me for this period. But as I went into specific instances of conduct during that time period, the court sustained the objection. So again, I felt that there has been a narrowing of my ability to put on evidence about the first 4 years, the policies that were implemented, things that I projected in the opening statement, I guess would be the fairest way to present it to the court. And I would ask the court if you can give me any direction on your ruling in that regard.
Well, so that is a motion. I'm trying to deal with motions and then,
All right. Well, Your Honor, I'll
let me
frame
get
it.
through all of the motions and then we can talk maybe about
Yes, Your Honor. I'll frame it
scope
as,
of evidence. Yeah, right.
okay, I'll frame it as a motion to dismiss based on the court limiting me from putting in that evidence to explain evidence as the state put it on. So I'll couch it in that respect and move on. I'll also state, Your Honor, that a motion to dismiss for the state to failure during its case in chief to have an identification of the defendant. I'll state that on the record. I'll also contend to the court, Your Honor, that I move to dismiss because we are here in this venue with Your Honor hearing it pursuant to, I've argued before, an administrative order under the Civil Rules 2.2 where the court is allowed to appoint himself to hear all matters in this case. I won't belabor the argument simply to say that I contend under North Carolina law that judges ride the circuit, that there are scheduling and calendars set in place. There are specific obligations set forth by the legislature as well as the judicial branch, and that this was deemed essentially a de facto exceptional case, which the court ordered itself on pursuant to this Rule 2.2 under local rules that govern civil cases. And I would contend that that was improper and that I'm not properly before the court, but you've seen the brief and the position. I won't argue it further. Your Honor, I have not contended, charged as a district attorney and a constitutional officer with not only duties and obligations, but also authority and discretion. I would contend, Your Honor, as to all counts, taking the case in the light most favorable to the state, that the facts submitted were within the constitutional authority, with the exception of evidence where witnesses have said that I specifically directed them to do something that was an unlawful act. Now, I contend, based on the evidence you received from AOC about the effect of entering beacon hours and the approval thereof, that this administrative function does not rise to the level of a criminal act. I also contend that, based on the evidence, it is uncontradicted that the SBI contacted me on August 10th and did not announce that this was a criminal investigation, nor that a judge had sanctioned the investigation. As of September 6th, I can't say that because the facts are in dispute. But the facts are not in dispute as to that phone call on August 10th. I would contend, absent notice to a district attorney in the state of North Carolina, that a judge has signed an order authorizing an investigation or notice from the SBI agent that the district attorney is the subject of the investigation or is acting under some other authority, that the district attorney still has discretionary authority to remedy matters with his staff, to investigate cases, whether administrative or criminal, and fully act as a district attorney. So in that context, I would make a general motion to dismiss as to all charges with regards to the facts elicited by the state in a light most favorable to them. I had one more, Your Honor, and then I'll sit down. We could have 1 second, Your Honor. Oh, that's it. I have made pretrial motions to dismiss on failure to comply with discovery. They've been denied. The court aptly pointed out to the defense, you were not convinced about materiality. But now at the close of state's evidence, I move to dismiss all these charges and contend the court can conclude not only materiality of the issues raised before, but two bright line issues for the court to hang their hat on. There is a computer seized by the SBI, identified as Cindy Blitzer's computer, that was seized for forensic testing, and it was testified by the agent that upon Cindy Blitzer simply saying, I did no work from mid-March to October 24th, that upon that declaration by a very credible witness, they just decided not to test evidence. I contend where the state has seized and taken evidence with potential exculpatory information on it, they cannot then just sit on it and do nothing with it and try a defendant for multiple felonies. I would also contend it was admitted to by Agent Whitley that Elisa Black was also given as a witness with potential exculpatory evidence with regards to Cindy Blitzer working. And the agent said he did not interview her. It was also noted on cross, and this is a little bit less effective argument because I was able to mitigate it a little bit, but the context of Tyler Henderson's refusal to engage, the agent said, I should have done a report on that because of that negative encounter, and did not. In addition to that, I elicited today, there was conversation between the supervisor in Greensboro and the supervisor in Raleigh, which is also the subject matter of the Ray Richardson case, which the court has kept out for the time being, about modifying the requester letter, which included adding specific names with regards to the scope of the investigation. I contend that the defense was entitled to that information. If two supervisors are talking about the why they're modifying a letter for an investigation and it's not documented and not turned over, and changes a letter from the enabling authority of Judge Crosswhite, takes his letter, sends it back and says, no, do it this way, that is also discoverable evidence. Now I concede, once the Superior Court judge elected to sign the letter as amended, he still has authority. I concede that. But it is discoverable evidence that has not been turned over. Not to mention the obvious that has been probed during the state's case. ADA Ramey had contact with another SBI agent, and despite Tom Ford, the prosecutor, sending out an agent to investigate why there's a 3 or 4 month lapse in any notes of what happened, and the court ordering, and they checked and responded there's nothing there, we still have no discovery about that time period. Why is that important? Why is it material? Because the state alleges this offense started April 1st. Yet state's evidence indicates the SBI is on notice of this offense prior to April 1st. Maybe as early as December of 2015. How can a defendant file an entrapment motion or something akin to latches or some other defense when the SBI is sitting on an allegation before an offense date occurs? I won't get into the argument now of their obligations of contacting a hiring authority or a person in authority. The closest I have to it is Judge Smith contacted AOC and Judge Crosswhite was appointed. But shouldn't an agency in North Carolina, if there is this issue of whether an employee is getting a salary like a trooper who's sitting at home in the afternoon rather than being on the road, we've heard those stories, there's got to be a mechanism where the constitutional officer, the hiring authority, or if they don't trust them, AOC is put on notice that the house is on fire. Surely the state can't sit back for 4 months and wait for the house to burn and then go through an investigation for another 4 months before they even notice the hiring authority and then come back and prosecute them because something happened after they were already on notice that there was this issue. So that is another area of discovery that has not been turned over to the defense. So with all of that in mind, Your Honor, I simply add two other things. Isn't the internal affairs investigation into this portal issue within the files of the SBI law enforcement agency? And was there not any consideration where the agent had notice of this investigation to turn that over to the state? I know at this point the court has sealed most of it, but shouldn't the defense have been given that in discovery? I contend we should have. The quality control issue, which you did order, is something, again, that didn't have knowledge of, learned during the course of the trial. Any evidence that affects the credibility of statements, surely an internal mechanism that says notes are transferred to a typewritten statement the next day versus 15 days later is evidence that would tend to add credibility to or impeach a statement. And it's documents within the possession of the SBI which have not been turned over. Finally, and I move to dismiss on those discovery grounds. And the final, if I could, Your Honor, I'll label as an exhibit if you'd like. I would like for you to look at the Judge Stoltz statement and the notice that the defendant was on with regards to the allegations in the pleading. For in addition to considering the insufficiency of the evidence, the fundamental fairness to the defendant in preparing a defense, given the allegation of what happened on August 12th. I ask you, Your Honor, I know I'm at the end of my rope in terms you hear me, but let me just say this. Tom Ford apparently drew this indictment consistent with this statement that there was contact on the 12th. The information was given to Judge Stoltz, and that it caused him, the false information, caused him to go enter Beacon. Now, state's evidence is on August 15th, everything happens on the same day, and he's told to enter it into Beacon. So I ask the court to consider either dismissing or granting a mistrial with regards to the charge of obstruction as it relates to Judge Stoltz. Will you?
I'll be happy to receive it. It's not, I'll be happy to look at it in connection with the motion to dismiss. It looks like counts 4, but I'll be happy to consider it.
Thank you, Your Honor.
All right. So with respect to the latter motions that you've just made, I'm not talking about the motions to dismiss counts 1 through 7, which I'll receive additional legal authority from you on prior to 8 o'clock tomorrow morning. But with respect to the motion for the renewed motion for mistrial, the motion based on the chilling effect on your election, whether to testify, my decision to not disqualify myself from this case, your inability to call me as a witness in this case, the limitations that I've imposed thus far on the relevant scope of the time frame for evidence, the motion to dismiss for failure to identify the defendant, the designation of this case as an exceptional case that I received a commission to try, the motion to dismiss based on your arguments relating to your position as a constitutional officer, and the failure to comply with discovery. All of those motions are denied. I will receive the document you're talking about with respect to the statement of Mr. Stoltz and consider that in connection with the remaining motions to dismiss that we'll rule on tomorrow morning. And then you also indicated that you wish some guidance on the scope of evidence that you'd be permitted to offer with respect to your hard work and diligence during your first 4 years as district attorney. Is that correct?
Well, in summary, but yes, in terms of policies and procedures and unique programs that tend to explain unique programs that was done during this offense period time, Your Honor. So it's not character evidence. It's to show policies and procedures and the way the administration of that office ran, to show, although novel and unique, at all times throughout our history, there have been novel and unique programs that move us forward. In fact,
okay, I understand. I'm happy to give you some latitude, but candidly, when you present a witness list that is 127 names, I believe, my rough estimate was, many of whom I could only imagine. I mean, you've identified, with the exception of me, I believe every judge who rotated through your district. So, candidly, I do think some constraint on the type of evidence and the cumulative effect of that evidence of these novel and unique programs that you're describing, the court's entitled to place limitations on that. And I have attempted to do that in a way that fairly balances the opportunity for you to portray the hard work of people within your office, including yourself, some degree of latitude on discussing novel programs that you had, like digital document transmittal from local law enforcement agencies to yourself. You've had some latitude on that. So, quite candidly, no, I'm not going to allow this to become a trial where you get to essentially say, look at all the great things I did over here, and ignore the issues of this trial as to whether the state has met its burden of proof as to the allegations of the conduct that's described in the indictment. Now, if you can show in fairly short order that a program that you initiated, let's say digital discovery, is something that has a nexus to the crimes that you are charged with, then of course you can present that information to the court. But I think that nexus has to become evident pretty quickly, because I'm not inclined to allow you, just like I say, to call witness after witness to say he did a wonderful job in his first 4 years.
I agree, Your Honor.
And, or that he tried a lot of cases, or that, they were efficient in trying cases, or that his wife worked hard, or any of those things. I mean, if there is a nexus to what you contend Ms. Blitzer was doing during these months, or what you instructed her to do, fine. You certainly can put that into context by explaining what that program was. But from where I sit, I need to see that nexus, and from where I assume the jurors are sitting, I think everybody needs to see that nexus pretty quickly. And to the extent you can establish that nexus, then you'll be given latitude to describe how that program worked, why it has some materiality to the defense. And I don't know whether that's guidance, but now that we're sitting at a point where the state is rested and you've indicated that you intend to present your evidence within 1 week, then I'm assuming that a number of these folks won't be called and that we're not going to be sitting listening to a lot of good things that happened during some time period that's not of relevance to the offenses that are charged in this case.
Yes, Your Honor. That list was based on 14,000 pages of discovery.
I understand.
The state
You don't need to
has-
defend it. I'm just trying to give you a narrowing, an indication of my view of why the facts in this case, the evidence needs to be constrained to a relevant period relating to this offense date. If you believe that there's activity that occurred outside of that relatively narrow period of time that relates to the offenses in the indictment, if you can establish a nexus in fairly short order with the witness, then you'll be given latitude to describe that in greater detail. But we're looking for that nexus.
Yes, Your Honor.
All right.
I would just simply further argue that in that same spirit of judicial economy and fundamental fairness and due process is why I seek information on the indictment so that I'm not spending a lot of time disproving a lot of things that the state is not relying on, for example, as a false representation or a time period that's not at issue.
Right. Well, you do have the benefit of being at the close of the state's evidence, so you know what their evidence is. You do not need to speculate as to what the state's evidence is. You now know what the state's evidence is, and so you can focus on those matters. The state's not going to be permitted to argue evidence that's not part of the record.
Thank you.
All right. Very good. Are there other matters for the state?
No, Your Honor.
All right. Anything else, Mr. Bradsher, before?
Yes, Your Honor, just a time for the court to consider and give Ms. Strickland an opportunity to be heard on other documents within the file that you believe may be disclosed from the administrative investigation of the SBI.
All right. You'll need to be more specific. I mean, the takeaway that I got, I've not looked for any additional files. I know that you were interested in what those two referenced files were, and I'm satisfied that there's no further indication of that in the file. Specifically, what other information are you seeking from this file, knowing that you haven't had a chance to look at it? You don't know what's in here.
Just from what you indicated, Your Honor, there are screenshots and a methodology to show how it was determined these two items were actually downloaded and where they went to. As I've already reported to the court, I was only handed the case identification sheet.
All right.
And
I will attempt to have an email transmitted. It may not be able, my judicial assistant may not have time to do it today, but I'll attempt to review the documents again tonight, and if there are other documents that I believe could provide information on that going through the balancing tests I've already described should be disclosed, I'll identify those. I'll send an email like I did this morning and give Ms. Strickland an opportunity to voice any concerns she has.
thank you, Your Honor. Is there a particular letter I should put? I know letters for court exhibits, A, B, C, or
Do we have court exhibits?
As far as letters, well,
C.
may I approach with defense?
Yes, please.
exhibit C? Thank you.
Can I see what's going on?
Secret notes.
I just saw some emails on there.
Yeah, it's part of the statement. Thought you brought them in there to give context.
So I just wanted to make sure that's what they were. I saw that.
Thank you.
Yeah, thank you. All right, then we will be in recess until tomorrow morning at 9:30.
Real court stands in recess till tomorrow morning, 9:30, contact is on the court.